Thanks for joining us tonight. We start a serious topic. Should domestic abusers have the right to own a gun? That was the question at the center of a case in the nation's highest court this morning. The challenge is coming from a man in Texas, where that man is accused of assaulting his girlfriend and threatening another woman. And he was told by the court after that he couldn't own a gun under his restraining order. But then he violated that restraining order and wound up in jail. This might seem like a clear-cut case, but it wound up in the Supreme Court because the court is trying to clear up a lot of confusion about where it actually stands when it comes to the gun rights of a person and the Second Amendment. And as Kent explains tonight, this case could lead to several more.
This case is literally life or death.
Hundreds of protesters rallied outside the Supreme Court this morning, while justices inside considered a case challenging a federal law meant to keep guns out of the hands of domestic abusers.
The federal law, which is now almost 30 years old, says if you have a restraining order against you because you did commit domestic violence, you are deemed a dangerous person, and dangerous people should not be carrying around guns in society. The defendant in this case actually had 5 different occasions where he shot a gun in public and was deemed a dangerous person in Texas.
Seems like this is a pretty clear-cut case for why the federal law would exist.
Yes.
But U of M professor and Supreme Court scholar Tim Johnson says attorneys for that defendant, Zackey Rahimi, are arguing that a landmark gun rights decision made by the court's 6 conservative justices just last year invalidates that law and others like it.
Now the only way we look at gun regulations, whether it's to ban a gun altogether or to regulate the usage of that gun, has to be based on historical context where you would point to something in the history of the United States, preferably as near the founding as possible, where such a regulation existed. And Mr. Rahimi and his attorneys are arguing that there was no regulation on domestic violent offenders possessing guns back in 1805 or 1791, and therefore that regulation cannot exist in 2023 either.
If the majority of justices agree, Johnson says this case would just be the beginning.
If you cannot regulate someone in this case who has a protective order against him for having allegedly committed domestic violence, then there's almost nobody who could be barred from possessing a gun in the United States.
But looking back at that big decision from last year, Johnson does not believe that will happen, pointing to Justice Kavanaugh's concurring opinion, joined by Chief Justice Roberts, that there are limits, writing, properly interpreted, the Second Amendment allows a variety of gun regulations.
I think that this might very well be one of those cases where one of those limits is if you are dangerous. So for instance, Chief Justice Roberts asked at oral argument this morning questions that forced Mr. Rahimi's attorney to actually concede the fact that Mr. Rahimi was in fact dangerous.
And Johnson says a previous opinion written by Justice Amy Coney Barrett suggests she'll draw a similar line.
She wrote, it is in writing from her time on the 7th Circuit, that she thinks the standard probably is dangerousness. And now you've got at least 3 justices who could jump with the liberal coalition, and all you need is 2 of them to form a 5-justice majority.
And no matter what side the majority ends up taking, he says what they write about it will matter even more.
Judges aren't exactly sure how to apply this standard right now, and what they're really looking for, really needing, is for the Supreme Court to clarify.
The courts won't get that clarity until the spring, and Johnson says once it comes, it could help settle some cases, but would also lead to more new challenges when it comes to the regulation of firearms.